Hey friends. Okay, let me just check one thing because I didn't do this before I started. Obviously, you can see me, I think. But let me just check my audio and make sure. Okay, perfect. I hope everyone had a great Thanksgiving and felt some love today. That is, did I just say Thanksgiving? I'm so confused. Forgive me. Let's start over. It sounded in my head as that was repeating back to me, and I'm not sure if you heard it, but it sounded like I said Thanksgiving. And if that was the case, it's been a long day. But happy Valentine's Day. If I didn't say that the first time, I hope you felt a ton of love today. I am back tonight. We are going to go through a couple of the exhibits of the lawsuit that we started earlier this week. So I stayed up late Wednesday, I believe it was, into Thursday. That was a mistake. Thursday was a disaster. I was so tired. I had the worst headache. Um, did I learn my lesson? No. Here we are again. But my kids are asleep, my husband's asleep, so we're just gonna don the glasses. Um, you will see that since we met last, I printed the lawsuit that we talked about on the 12th, and I have annotated it. So I have some thoughts. There were 8 attachments, I believe, to this lawsuit. 7, 8, 8 attachments to the lawsuit. And there was one thing that I found that was not included as an exhibit in the lawsuit that I think would behoove us to review as part of this. So for those that missed the first live stream of and you would have unless you're up all night. But I'm going to recap for those really quickly who are not even sure what I'm talking about. And then I am going to go into some exhibits. I am going to be going back and forth in my notes. So I'm sorry if you hear that on the microphone. But okay, quick recap. And I am going to read this again from the introduction of the lawsuit. Oh, before I do that, I hope if you're still awake at 11 o'clock at night, that you are enjoying some type of beverage. This is a vodka tonic tonight. The other night I had a really great wine from Portugal. This is Tito's and tonic. Um, on the rocks. Okay, but quick summary recap. Basically, the crux of this lawsuit is around a meeting that was held in June of 2024 where it was meant to be a meeting to introduce and get our new board members in their seats, right? Um, but it went a little bit beyond that. So in spring of 2024, a majority of the eligible property owning members of the Fairfield Harbour Property Owners Association successfully voted to remove two members of the board of directors on June 28, 2024, in an unveiled effort to protect themselves from meeting the same fate. A majority of the remaining directors of the board unlawfully purported to hold a vote amongst themselves, not including the members, but amongst themselves, the board of directors, to change the association's bylaws. Specifically, the board voted to require a supermajority vote of 67% of members to remove a director when the existing requirement for removal was a majority of the members. Okay, so tonight I have several things up I have available for us to review. Just quickly, I'll go through these things. I have the lawsuit. I have the letter to Hope Carmichael. This is one of the items that was not in the lawsuit as an exhibit, but that I want us to review in the lawsuit. Exhibit 7, I believe it is Hope Carmichael's response to Wesley, but we didn't have the whole letter in full there. So I pulled that over. And then, just for the sake of making sure that we have enough to talk about, I have pulled over the North Carolina general statutes. That those are referenced a lot in this lawsuit. We also reference North Carolina General Statute 47 in this lawsuit, and that is for nonprofit corporations. So, yeah, I'm going to go through them. So let's start here, shall we? I have some things highlighted and some notes that I want to take. I'm going to start with Exhibit 5. All right, on June 28th, 2024. I'm reading from page 14 of the lawsuit itself. Okay. On June 28th, 2024, the board of directors held a meeting. The minutes of this meeting are attached here to as Exhibit 5. At no time prior to the meeting was noticed that a motion to amend the bylaws would be made, and this item was not listed in the meeting's agenda. Okay, so that is, in my opinion, kind of the crux of this entire thing. So that is numbers 89 and 90. And I'm going to take us through to Exhibit 5. I'm going to pull it up on my computer, but I've also made some notes for me. All right. Let's pull up Exhibit 5. Oh, I'm almost there, I think. God, that was good timing. Look at this. Exhibit 5 right here. All right. So again, this is the Fairfield Harbour Board of Directors and Officers June 28th meeting. It started at 1 o'clock. There was a limited executive session that was held as part of this. The agenda, right? So that's what we are reporting in the lawsuit, was not there. There was nothing on the agenda or in any type of notice of the meeting that there would be a call for change to the bylaws. So the agenda was call to order, election of officers for 2024-2025, governance question and answer with general counsel. Items for discussion and action were approval of construction loan from Truist Bank and engagement of general contractor for construction of the Harbor Club. And then it was to be adjourned. So 1, 2, 3, 4. 4 has an A and B, and then we're done for the day, right? So I'm going to skip through to this. It's on page 2. So after we make some quick notes of who's present, what guests are present, the meeting was called to order at 1:06. The first order of business was to elect new officers for 2024-2025, right? So we're tracking with the agenda. Director McLam made a motion to elect Director Carolyn Gale Albertini to the position of president. A second was entered by Director Brody. Approved Directors Albertini, Barajas, Brody, McLam, Moore, Pendleton, Peppercorn. Opposed? None. Motion passed unanimously. President Albertini made a motion to elect David Peppercorn to the position of vice president. McLam seconded. It was approved. No one opposed. It was passed by unanimous decision. Attorney Carmichael gave a short presentation on what fiduciary duty is and the responsibility of board members. I feel like all of us could use Hope's expertise in just explaining what fiduciary duty is and making sure we're on the same page. But then she also gave everyone a code of ethics to sign for the 2024-2025 C's session. At this point, Director Pendleton asked if it would be possible to amend the bylaws so that the petition for removal of board members would have to have calls and a supermajority. Director Pendleton made a motion to add a bylaw change to the end of the agenda. It was seconded by Peppercorn. It was approved by these folks. It was opposed by Directors Barajas and Moore. Again, we mentioned this in the last live stream, but these 2 board members that opposed were the brand new board members just added to the board, okay? The motion passed by a majority vote. We then go straight into members of the Harbor Club Committee joining the meeting at 1:40. Everybody introduced themselves. We talked through a bunch of things I'm not gonna get into because I don't think my blood pressure can take it, but I'm gonna stick to my logic here because this seems like a threat, this paragraph, and I'm gonna read it. I'm gonna read it out loud. I've read it in my head up until now, but I was like, "This really happened in real life with adults." Treasurer Miller, I'm right here in what is paragraph 3 of this page. Treasurer Miller welcomed directors Barajas and Moore to the board, and he stated that over their 3-year term, meaning he is directing these statements to Barajas and Moore. Over their term of 3 years, there will be conflicts of interest and there will be differences of opinion, but you will be working with the same people, and we try to be civil. We try to be civil. If you are here to profile FH Stop, you are in the wrong place. If you are in support of the board, you will follow North Carolina F47F and 55A POA bylaws and policies. Fairfield Harbour has been in existence for a long time, and many people have put a lot of work into making this place successful. There is a cost, that's a typo, but there is a cost of $5,000 to $8,000 in expenses for each vote you want. FH Stop is trying to run this place by Facebook, and it has created a monster. You are not our enemy, and we will treat you as such. Hey, gentlemen, this is how in my mind, God, Mr. Barajas and Mr. Moore, I can only imagine what was going through their mind. But like, we're new here. Like, let's put ourselves in their shoes. We're new here. It's our first meeting. We've just been elected into 2 new board of director positions after there was a vote held that passed to have 2 members taken off of the board for cause, right? So we just, as a community, a majority of us got together, said we want these 2 people off the board. That passed. They're gone. We get these 2 new people in. It's their very first meeting. And they have to listen to somebody on the board be like, "We're so glad you're here. But let me tell you something. If you think that you're here to ruin what a lot of people have put a lot of time into to make this place the place that it is, the place that is a lot of dissension and division right now for no apparent reason, you are in the wrong place. We try to be civil around here, but what did he say here? There is a cost of $5,000 to $8,000 in expenses for each vote you want. Who the fuck is the you? They didn't ask for a vote. If I recall correctly, at the very beginning of these meeting minutes, it was Pendleton who asked for the bylaws to be changed, and that was approved by vote of the board of directors to be added to the end of this meeting's agenda. Chris and Don didn't come to this board meeting or add to the agenda beforehand, "Hey, we would like to throw a whole bunch of votes out there." So there are assumptions being made about why these 2 gentlemen are in the room. And we're just going to level set this playing field right now. If you think you're here to play for FH Stop, don't bother. We try to be civil, but I'm telling you right now, this is a line. This is their very first meeting. I mean, benefit of the fucking doubt, man. I swear, I read this. I was like, who asked for a vote? It cost us $5,000 to $8,000 for each vote you want. You didn't ask for a vote. Barajas and Moore didn't ask for anything. You're just putting it out there on the table. Anyway, Directors Barajas responded that he nor Director Moore are they are independent of FH Stop and represent the people who voted us in, which was a majority. It was a majority. So then we just let that dog lie. And we go on about our business for the 15 budget cycles for the Harbor Club and the preliminary budget that was passed in January of 2024. I can't even imagine that we've had this meeting. We've had these people come in to talk about the Harbor Club. We've had Hope talk about our fiduciary responsibility and give a code of ethics to be signed. And we just, this is what I'm talking about. This is why people, and we wrote it up in the meeting minutes as such. Like, I mean, this poor lady, Robin, was typing so fast, she even made misspellings. We didn't even get the whole North Carolina General Statute. We don't even know what 47F and 55A. There's a missing comma between POA bylaws and policies. Like, this poor woman is typing so fast trying to get the context and the information for those of us that are not able to attend. It's too much. Okay, we go on. The board goes into executive session. They come out. The Harbor Club committee comes back into the room. Talk about a couple things Harbor Club related. Mr. Pendleton thanked everybody for their hard work over 6 years to make the Harbor Club happen. When you keep in mind that a typical board of director person is on the board for 3 years, maybe serves 2 terms, so that's 6 years. It's taken 6 years to get to this point, to cause this much chaos. But whatever. He thanked everybody for their time, for all their hard work, and I do. Thank you. I think so many things. But we're gonna send out a special notice to the community announcing the vote, and then they left the room. We made a motion to keep Rhonda as secretary. That was approved and passed unanimously. We made a motion to have Kevin Heidel continue as treasurer. That passed unanimously. Moore made a motion to have Rich Miller continue as the treasurer or assistant treasurer. That was passed. Nobody opposed. And then Director Pendleton made a motion to go back to his first comment at the beginning of the meeting to amend the bylaws by stating that any vote for removal of the member of the board, including current members, will require 67% of POA members who are eligible to vote according to the POA bylaws in effect at the time of said recall ballot is distributed for voting. Albertini made a second. It was approved by all these people except for Barajas and Moore. Motion was approved by a majority vote. Then we see FHPOA bylaws Article 5, Section 9, Paragraph A. And then Attorney Carmichael is going to send Secretary Miller the exact wording needed for the amendment. Keep in mind that Hope Carmichael, the lawyer representing Fairfield Harbour Property Owners Association, also helps write the laws that govern what POAs can and cannot do. So, hey, we snuck this in unannounced on the agenda. It passed by a majority vote, and I'm going to, just to make sure all of our I's are dotted and our T's are crossed, I'm going to send you the exact wording that you need to put in here, okay? So I want to go to this section. Hold one second. What page is this? So this is our bylaws. So Exhibit 2 of this document, let me remember that I'm on page 86. Um, oh, I'm so close. One more back. Okay. So, with the exception, I'm gonna just skip here to section 6. So we are what, article are we in? Article 4, and in section 6, with the exception of DOR amendments, which require 67% affirmative to change, and the election of directors of the Fairfield Harbour POA, plurality vote, so a majority of members, right? This is what they currently say. This is quorum. Um, any meeting of the members of the association at which quorum is present, or any vote by mail-in ballot without meeting where a quorum has participated, the vote of a majority of those votes cast shall be necessary for the adoption of any matter voted upon by the members. The members present at a duly organized meeting at which a quorum has been established may continue to do any and all business until adjournment, notwithstanding the withdrawal of enough members to leave less than a quorum. Okay. So then we go here to, I think it's, I'm going to go to, still in Article 4, but I'm going to go to section, no, I'm in Article 5, Section 9. Removal of directors. So keep in mind, these are the amended and restated bylaws from 2020. This is what we're changing. So this is where they stood at the time of this June 28th meeting. Pursuant to North Carolina General Statute 55A 808, Article 4, Section 4B of these bylaws, directors may be removed from office with or without cause at a special meeting of the members of the association specifically for such purpose. Okay? Um, Now I'm going to go to, just going to show you what the, so in Exhibit 6, Exhibit 6, we have changed that wording to say a vote for removal of a director may be called by the board of directors or by petition of members for a special meeting as otherwise provided in these bylaws, provided, however, that the vote required for removal of a sitting director who has been duly elected or appointed pursuant to these bylaws shall not be less than 67% of the eligible vote of the POA. So you need a majority vote. You need a majority vote to be elected, but you need a supermajority to be removed. Why should it take more? Because we didn't change what it takes to be elected. That's still the plurality. Why should it take more to get you out of office than it took to get you in office? That makes no sense. If you come in, if we elect you in because we think you are the best person for the job out of the candidates that ran, and we voted you in to represent us and make our community as great as it can be. If we voted you in and you prove to not be doing your job or are running or are actually taking action against the platforms that you said you were voting on or that you said that you would do, or you're just doing a shitty job, period. Why do I have to move heaven and earth to get you out of your job? Like, if there is cause to want you removed from your position before the end of your term. Why do I need more evidence to do that than I needed to put you in office? That doesn't make any sense. That's part of the reason why this lawsuit exists. Okay. So that's one thing. That is exhibits 5 and 6. The other exhibit that I wanted to go through here, I'm going to switch us over, I think, to here. This is what I think is important. So on October 9th, so this happened, this meeting that we're talking about where the bylaws, the board of directors made the motion to amend the bylaws, and that was approved by majority, not unanimous. That happened in June. In October 9th, there was a lot of work done between June 28th to get us, and I say us, to these 74 people that worked with a lawyer to get all of this documented, right? This is the original letter that went out on October 9th. Dear Hope, so his name is Wesley Collins. Dear Hope, as you know, I represent a group of owners in the Fairfield Harbour subdivision. I understand that there was a recent special meeting called for the purpose of conducting a vote on the issue of removal of 4 members of the board of directors. You have confirmed that there were 712 proper votes cast against removal and 781 proper votes cast for removal. I further understand that the association has concluded that the vote for removal does not pass, right? So we had a special meeting for the people, the 4 additional directors that we wanted off the board. We had 2 successfully removed. We had a special meeting. We had enough votes to call a special meeting. We were putting on the table having 4 more of the legacy board removed from position. It was voted to remove those 4 people, 781 valid eligible votes to 712 votes against their removal. Again, a majority. I further understand that the association has concluded that the vote for removal does not pass because the 67% affirmative vote for removal was not achieved. Upon review of the governing documents of the association, the applicable law, and the documents relating to the purported amendment of the bylaws, I have concluded that the affirmative vote required for removal is majority, or 50% plus 1. Since the affirmative vote was 52.31% for removal, the motion in fact passed. It's my opinion that the recent purported amendment of the bylaws was not conducted as per law and thus is a nullity. This results in the affirmative vote required for removal of a board member being 50% plus 1, not 67%. As to the purported recent amendment of the bylaws, Resolution 2024-03 states that the amendment was by affirmative vote of 5 of the 7 directors of the board. It is clear that the attempted amendment was by vote of the directors. Such an amendment by vote of the directors must comply with General Statute 55A-10-20, Amendment by Directors. Said statute does not contain any language that would allow bylaws, declarations, or articles to alter or relax the requirements of North Carolina General Statute 55A-10-20. So if we look at 55A 10-20, let's follow a logic train, right? Let's not get off track here. Let me move my papers. Hold, please. I have to do this on another screen. 55A. Amendment by directors. Okay. If a corporation has no members entitled to vote thereon, its incorporators, until directors have been chosen, and thereafter its board of directors, may adopt one or more amendments to the corporation's bylaws, subject to any approval required pursuant to General Statute 55A 1030. The corporation shall provide at least 5 days written notice of any meeting of directors at which an amendment is to be voted upon. That notice didn't happen. The notice shall state that the purpose or one of the purposes of the meeting is to consider a proposed amendment to the bylaws and contain or be accompanied by a copy or summary of the amendment, or state the general nature of the amendment. The amendment shall be approved by a majority of the directors in office at the time the amendment is adopted. Okay? So that's great. Board of directors can make a change to the bylaws given that there is notice at least 5 days prior to that meeting that says the purpose includes the consideration of a proposed amendment change to the bylaws. Okay. So I'm just going to, for shits and giggles. All right. If we do 55A-10-30, approval by third persons, the articles of incorporations or bylaws may be required by an amendment to the articles of incorporation or bylaws to be approved in writing by a specified person or persons other than the board of directors. Such a provision in the articles of incorporation or bylaws may only be amended with the approval in writing of such person or persons. Okay. So if we go back to this letter. In North Carolina General Statute 55A 1021, amendment by directors and members is not the operative statute because no membership approval was sought. Said statute specifically requires approval by a certain fraction of members. So let's go to 55A 1021. 55A 1021. Amendment by directors and members. If the corporation has members entitled to vote thereon, then, unless this chapter, the Articles of Incorporation, bylaws, the members acting pursuant to subsection B of this section, or the Board of Directors acting pursuant to subsection C of this section, that's here and here. I'm not sure if you see my mouse, but we're going to read them. Require a greater vote or voting by class, an amendment to a corporation's bylaws to be adopted shall be approved by the board or in lieu thereof in writing by the number or proportion of members entitled under GS 55A 702, Section A2. To call a special meeting to consider such amendment by the members entitled to vote thereon by 2/3 of the votes cast, or a majority of the votes entitled to be cast on the amendment, whichever is less, and in writing by any person or persons whose approval is required by provision of the Articles of Incorporation authorized in GS 55A 1030, which we just read. The members entitled to vote thereon may condition the amendment's adoption on its receipt of a higher percentage of affirmative votes or on any other basis. If the board initiates an amendment to the bylaws or board approval is required by subsection A of this section to adopt an amendment to the bylaws, the board may condition the amendment's adoption on receipt of a higher percentage of affirmative votes or on any other basis. If the board or the members seek to have an amendment approved by the members entitled to a vote thereon at a membership meeting, the corporation shall give notice of the membership meeting to those members in accordance with GS 55A-7-05. The notice shall state that the purpose or one of the purposes of this meeting is to consider the proposed amendment and contain or be accompanied by a copy or summary of the amendment. If the board or members seek to have the amendment approved by the members entitled to vote thereon by written consent or written ballot, the materials listing the approval shall contain or be accompanied by a copy or summary of the amendment. Okay? The corporation shall provide at least, so we're going back to 55A-1020. The corporations, and we're just doing a relevant part, the corporation shall provide at least 5 days written notice of any meeting of directors at which an amendment is to be voted on. The notice shall state that the purpose or one of the purposes of the meeting is to consider a proposed amendment to the bylaws and contain or be accompanied by a copy or summary of the amendment or state the general nature of the amendment. Based on the meeting minutes resolution from the June 28, 2024 meeting in which the bylaws were purportedly amended, there was no 5 days written notice as required under General Statute 55A-1020 provided. The minutes specifically indicate that the issue was presented at the meeting by motion. Failure to meet the notice requirements of North Carolina General Statute 55A-1020 renders the purported amendment void ab initio, and we learned earlier this week that was void from the beginning. Thus, the affirmative vote required to remove the board members at the recent special meeting was 50% plus 1. The vote passed and the 4 members were properly removed. By this letter, I hereby demand that the Board of Directors for Fairfield Harbour immediately acknowledge in writing that the recent vote to remove the 4 members of the Board of Directors passed and that replacement members be put in place as per law. Furthermore, I hereby demand that the 4 removed members abstain from any further involvement or actions as purported members of the Board of Directors. This demand is tendered pursuant to North Carolina General Statute 55A-740 derivative proceedings. If the association fails to provide said acknowledgement to me in writing on or before October 18th, 2024, I will be forced to proceed with a derivative action in which I will seek a declaration from the court as to these issues and recovery of attorney's fees and costs as per General Statute, North Carolina General Statute 55A-740E. Furthermore, any actions by the board or the remaining members of the board which are inconsistent with the law will be considered ultra vires. We remember that, right? Ultra vires, you know. Beyond the powers. That's going to be so hard for me. I'm going to stop talking about this lawsuit and I'm going to start using ultra vires in just regular speak. Beyond the powers, thus exposing the individual board members to personal liability. The voice of the association has been heard through the vote of the membership. The members properly removed 4 members from the board. The association must recognize and acknowledge this proper action, and the governance of the association must proceed consistent with this proper action of the corporation. Signed, Wesley Collins. Okay? So if we go back to our lawsuit, this is Exhibit 8. This is the last exhibit. Okay, this is Hope Carmichael's response on behalf of the board to Wesley's letter. And this letter is dated October 18th, the day of the deadline. It's great. So, dear Wes, I write in response to your correspondence of October 9th, 2024, which was sent on behalf of a group of unnamed property owners within Fairfield Harbour, purportedly as a demand pursuant to North Carolina General Statute 55A 740. The association will not be taking the action demanded for the reasons set forth below. 1. Derivative demand. I will again point out that after numerous communications, you have still failed to identify any client whom you are representing. While you have stated that the purpose of your October 9th correspondence was to give notice under General Statute 55A 740, we do not consider a demand made by unnamed persons to be proper. You have not identified any individual with standing to make a demand and ultimately to initiate any derivative lawsuit. I love that this is the first paragraph and we respond with a lawsuit with 74 people named. Derivative action. In addition, we are aware that at least one current director has contributed to fund your legal fees. For obvious reasons, this creates a direct conflict of interest with any such directors being privy to any legal discussion regarding your threatened lawsuit. It's not a threat anymore. Not to mention attorney-client privilege concerns. Indeed, the failure of such individuals to disclose their involvement with you or your owner group, whether that involvement is formal or informal, is a breach of their own fiduciary duties and confidentiality obligations to the association. These circumstances present unique challenges for the current board of directors to engage appropriately with me as their general counsel while discharging all of our fiduciary duties, mine and the individual directors, to act in the best interests of the corporation. And I'm just going to say real fast, I hate that our community is referred to as a corporation. We are more business. This is why we have some of the issues that we have. We are more business than human beings. You know what I'm saying? Like, I I can't. Okay. Response to the demand. While the board does not consider your notice pursuant to GS 55A 740 to be valid, nor would this appear to be an actual derivative claim, I have nonetheless responded in the hopes that unfounded litigation can be avoided. Your specific demand is that the board acknowledge that the recent vote to remove 4 directors passed an outcome that is contrary to voting results. On June 28, 2024, a supermajority of the members of the board of directors voted to amend the bylaws of the association to require that removal of a director be approved not less than 67% of the eligible vote by the association's membership. This amendment was in accordance with Article 9 of the bylaws, which states these bylaws may be amended by the affirmative vote of 5 of 7 directors of the board. You have taken the position that this amendment was not valid, and under the prior wording of the bylaws, the 4 directors in question would have been removed from office. Your basic argument appears to be that the amendment was erroneous because of the association failed to provide at least 5 days notice of the meeting at which the amendment was going to be considered, in violation of North Carolina General Statute 55A 1020. The association does not dispute that the amendment in question was raised by motion at the board's June 28, 2024 meeting. The failure to provide notice of the potential amendment does not, however, invalidate the amendment. A basic tenet of corporate law is that a director's attendance at or participation in a meeting waives any required notice of him of the meeting unless the director at the beginning of the meeting or promptly upon arrival objects to holding the meeting or transacting business at the meeting and does not thereafter vote for or assent to taking action at the meeting. That's North Carolina General Statute 55A 823. No objection based on the lack of notice was made by any director at the meeting, and all 7 members of the board remained at and participated in the meeting, all as reflected by the minutes of the June 28th meeting. Accordingly, any notice requirement was waived. I have found no statutory or common law support for your bald assertion that the failure to meet notice requirements of this general statute renders the amendment void ab initio. And here's where he states in the lawsuit, I'm going to go back to the lawsuit itself. Okay. Let me just find what page it's on so I don't waste your time. Page 24. So we're on page 91 now. Perfect. The meeting's agenda did not include this amendment to the bylaws. Thus, the objecting directors could not object to holding the meeting or transacting business at the meeting at the beginning of the meeting, as nothing objectionable had occurred until the meeting was underway. So see, we get into semantics here, and this is why a lot of people choose not to engage with the board or have their name listed as someone who doesn't agree with them, because the devil is in the details, especially in this one. So Hope is saying that if you look at this North Carolina general statute, because Barajas and Moore were at the meeting, they waived their right to having needed to receive a 5-day written notice of the meeting and the agenda that would have included the proposed amendment, like bylaws change, right? She's saying they showed up. They never said they didn't want to be there. They never said they opposed the agenda for the meeting. So that waives, per that North Carolina general statute, the need for them to have gotten a waiver. Why send a waiver if you knew you needed to be there? What we are saying in this lawsuit is that because it was not part of the agenda, there was no waiver sent out with an agenda that let folks know what was going to be talked about before. So, but that didn't matter, right? Because we showed up. But then upon entering the room before the meeting started, they didn't say, oh, hold up. I don't agree with having this meeting or conducting business on behalf of this proposed agenda. They didn't know to say that because the agenda at the time, before the meeting started, did not include the need to have the amendment changed in the bylaws. That was brought up after attendance was taken and we started conducting the business. That's what's happening here in this lawsuit. So moreover, the meeting minutes stated that 2 directors opposed the motion to add the bylaw change to the end of the agenda. So they did speak up at the time that Les Pendleton said, hey, I want to make a motion to add this to the end of the agenda. The 2 directors made it known, we don't want to do that. We do not want, if you remember from the meeting minutes, Barajas and Moore opposed the addition of that item to the end of the meeting. So that is them saying, we don't assent to have that brought up during this meeting or to take action on that item. They did what they're supposed to do per the general statute. And then the 2 directors then persisted again in their objection at the end of the meeting by voting against the amendment that was discussed, even though they said they didn't want to discuss it. Just because the other 5 did want to discuss it because it was pertinent and critical to their continuation in the board of directors. So you cannot win for losing in this circular logic train that is happening here. You see what I'm saying? We didn't need to send a waiver because they showed up. Then, or a notice of a meeting because they showed up. So notice was waived. Then when it's brought up to be added to the agenda, they oppose it saying, we don't agree to it. And then when it is brought up anyway, they oppose the action. They're doing what they're supposed to be doing. You're not listening per usual. So the board of directors' failures, and I'm on 139 here on this page 24 of the lawsuit. Due to the board of directors' failures to follow proper procedures and to give legally sufficient notice concerning the proposed vote and amendment by the bylaws, the directors voted and purported amendment are ultra vires beyond beyond the power acts of the association and are void from the beginning. I got that one. Um, you have to kind of be able to go back and forth here and not. Okay, so here's where we were. We just finished this paragraph, the end of 2. We're getting ready to go into number 3. You have threatened derivative action, but frankly, that would not seem to be the appropriate vehicle for your client's claims. A derivative proceeding is one brought by a member to enforce a legal right of the corporation, while an individual action is one brought to enforce a right which belongs to the individual personally. If the claim is that the association failed to abide by its bylaws, that is the personal claim of your clients. There cannot be a derivative proceeding where there is no injury to the association, and the plaintiffs are not seeking to recover on behalf of the association. The appropriate claim would instead be this just drips of so many things. Like I read this and there's like an air of like holier than thouism. You know what I'm saying? Like, mm. That's how I perceive her, like having somebody type this up, like, please have them say this. I cannot even, like, that's what I see happening here, having met her a couple times. And that's totally me making assumptions and putting that I just it drips of disdain. There cannot be a derivative proceeding where there is no injury to the association and the plaintiffs are not seeking to recover on behalf of the association. The appropriate claim would instead be a direct claim for a declaratory judgment regarding the adoption of the amendment. Should your clients wish to bring an action for declaratory judgment to have their claim litigated, the association would not dispute that. There is an actual judiciable controversy between the parties for purposes of declaratory relief standing. However, the association does not dispute the propriety of a derivative action. Before proceeding, your client should also be aware that if litigation is commenced to challenge the bylaws amendment, the association will counterclaim with its own request for declaratory judgment related to the validity of the underlying removal request. The petition circulated for the removal of directors and the question put before the members was entirely inappropriate, says you. The petition sought removal of a deceased person, not deceased at the time, a person that had resigned, had not resigned at the time that we were putting this together, or any of their replacements for the remaining portions of any term without cause. It is axiomatic that before a director can be removed, the individuals voting to remove that person must know his or her identity. We did. We do. The association has no basis at the present time to challenge the validity of the removal question, given that the petition and subsequent vote had no effect on the composition of the board, but it should have because it passed by a majority. The association has no basis at the present time to challenge the validity of the removal question, given the petition and subsequent vote had no effect on the composition of the board, and any such challenge should have been moot. The reasoning does not apply, however, if your clients are seeking to invalidate the results as they now stand. Should you wish to discuss further, please reach out to me. The only thing that would have made this better would have been, instead of saying, "Dear Wes, I write in response," it would have started with, "I hope this letter finds you well." Like, anyway. So those are, I did not read through several. So there are 8 total exhibits to this. We read 3, 5, or 6, 7, and 8. Um, in here, I added the letter from the lawyer that was not as part of the exhibits, but the first 2 exhibits really, and then 7 was the results of the vote that they said did not pass, even though a majority approved to get rid of 4 more directors. And then the first 2 were the original bylaws, from 1983, and then it was a long time ago, and then the second one was the bylaws in their complete re-amended bylaws is the second exhibit. Um, and they're not material to the not all of our bylaws are material to this claim, this assertion in this action. And I said this in a Facebook post earlier. I know not everybody is on Facebook, but I want to applaud these 74 people. It takes a lot of guts to step out and put your name on a lawsuit when you feel that there has been an injustice. And I said I was not arguing with, but I was making a point about someone had posted about I forget even what they said because it's not really that important. But they had made a comment about, I forget the adjective that they used to describe the actions of these 74 members. It was inappropriate or childish, or I forget the exact adjective. But it's not. We should, as adults, be able to have a conversation, and if we cannot get to a mutually agreed upon conclusion, we part ways. Well, here, where we have homeowners within the community governed by a POA, when you get a lawyer to help you organize your thoughts, know if what you feel is happening is actually legal, and they give you information that makes you feel like you have something substantive to bring to the table and you are not being heard by the other side, or the other side has a claim that they feel like they can stand on that is varying from yours. That's what the justice system is for. We are asking in this lawsuit for a jury to be involved in the resolution of this litigation if it doesn't settle outside of court. And I can't imagine that it will, knowing the people on the board, but that's what the justice system is for, is to say, I believe this, you believe that. This is not a criminal act, right? But like this is, I have a belief, I feel like I was wronged. We have a belief, we feel like we didn't do anything wrong. I feel like I am materially damaged because of the actions that you took. We cannot get to a mutually agreed upon resolution. So let's take it before a jury of our peers and have them and a judge help us work through both sides and decide where cause lies, right? Like where who is right and who is wrong, and then that's what the justice system is for. We have 74 people that financially put their money where their mouth is and said, we believe that we have a case here, and we're not getting any justice when we try to go to the board themselves. They're not hearing us out. And then the board is responding in kind based on how they feel from their perspective. That's what the whole justice system is for. These people are still going to pay dues that go to pay legal fees for the board's attorney, Hope Carmichael. And they're paying for Wesley on top of that because they feel so strongly about the case. And I love people, regardless if you agree with me, but that have feelings, that are willing to put their might behind it. I think is setting a great example for everybody. We are not name calling. No one's damaging anybody else's property. We have a disagreement here that we cannot get to a resolution on. There are a lot of feelings involved. But this what this whole process is for, and that is not a bad thing. That is not a bad thing. Keeping it bottled up inside, not being able to go to the community center or the harbor club because you're scared you're going to run into somebody, blah, blah, blah. At the end of the day, this has nothing to do with the people. This has everything to do with the process that was followed. And I think that's what, especially on social media, people miss that point. But I'm just here to say that from my point of view, I'm just, you're setting a great example for how to go about doing this, why it's important to stand up for your rights, why our judicial system is so important to the integrity of our nation. It is a huge, I don't know. I applaud everybody that's doing this. I'm not going to clap too loud in the microphone, but I see I see the vision. I feel the vision. And I'm just proud of every one of you. And I know you're not going to hear that from a lot of people. I want to thank, and this, I mean, all the people on our board of directors who stand up for our community and who make their voices known, who stand in opposition to the mainstream, just to make sure that there is a voice of reason. There is a, not to be a barrier, but to just say, hey, let's play devil's advocate here. Is there a better way? Is there a more economical way? Is there something that we haven't thought of? Has our community changed in the past 6 years? Are we still on the right path? Just because we've always been marching in this direction doesn't mean we keep marching. If the community has changed to the point where our march is leading to a watery grave. You know what I'm saying? Like, there at some point, there has to be a voice of reason that can kind of back up, pump the brakes, and say, just asking a question here. Is this the right thing to do? And Barajas and Moore, for as new as they are to the board of directors, and them being able to, at a very first meeting, being talked to about this fiduciary responsibility, being handed a code of ethics to sign, which everybody's going to sign that. I think them facing that and hearing what Miller said at the beginning of this meeting, and in a really poor way, from my opinion, level setting the playing field and making them have to be forthright with whether or not they back FH Stop. It doesn't really matter at the end of the day. People on the board should be representative of everybody in our community, whether they're on FH Stop or not. So that really shouldn't have any bearing on their ability to do their job as part of the board of directors. If anything, they are adding another needed voice to the board of directors. So that's all that I have for this evening, but I did not want to end this week without going through the exhibits that were part of that lawsuit, because I didn't want the last live stream to be 4 hours, but the exhibits are important because they help tell the story. They substantiate the claims in the lawsuit itself, so they're important. So with that, I am going to let you go. Again, I hope you had a wonderful Valentine's Day, and I hope you have a wonderful weekend. It's supposed to warm up a little bit before it gets cold again here. And I hope you have a wonderful rest of your weekend. We'll talk soon. Bye.